Hello, everybody. Welcome at Betweenity's conference on Africa competition regulation. It is great to have you with us. We are being joined by participants from across Africa and Europe and the US, and we are really thankful for your wonderful support. Just a couple of words before we start with the panel. Betweenity is an independent news service provider dedicated to Africa competition law and policy. We monitor developments in all African countries and blocs in 11 languages, and we post the news on an online platform for our subscribers. Our clients span 13 countries and include regulators, global law firms, economists, advocates, and multinationals. Betweenity was established in 2020 and was born from the realization that the Africa Continental Free Trade Area Agreement will significantly speed up and formalize interjurisdictional competition law formulation, communication, and enforcement. A central resource capturing all developments would benefit professionals and regulators alike. In particular, it would speed up economic development because we would learn from each other and not reinventing the wheel. Areas closed off as a result of language barriers would start speaking to each other to solve problems. Now, the conference, which is our first, is one of our largest problem-solving exercises to date. Over the years, we have picked up deep trends and pressure points raising concerns, and some of these trends have not been addressed by your typical conference organizer because the data points have been dispersed in time, space, and language. But the impact on Africa, especially in relation to litigation and settlements, remedy negotiation, and distribution economics, have been enormous. We decided to bring these issues to the table together with Africa's brightest minds. Some of these trends that we will discuss at the conference include tribunal oversight functions appearing inadequate, settlement agreements appearing against public policy, some of the worst cartels not being investigated at all, very slow operationalization of new competition authorities, competition practitioners not always providing good advice, eliciting stern warnings from tribunals in Africa, competition regulations stifling supply chains, and competition remedies causing supply chain failures. Now, in my view, implicit in the above trend of remedies causing supply chain failures is a very strong reliance, sometimes subconsciously, of new classical economics. It may sound counterintuitive. I mean, we have all moved away from worshipping the pure market mechanism in favor of more pragmatic approaches to solving multidimensional problems. But think about this. How do we impose remedies, especially the ones dealing with SME promotion? Do we not actively try to make the large firm smaller through cost commitments and the small one larger through a lot of freebies and market protection? Is this effort not based on the deep-rooted belief that a combination of a lot of small companies is actually more competitive than the combo of a large player and two small competitors? Forcing a market to look competitive does not make it competitive. In fact, the above interventions may significantly injure a supply chain, especially if it ends up with a lot of new entrants, small firms, and cost-ridden incumbents. Such a supply chain may be much less resilient in the face of supply shocks. A redesigned market may look competitive from the outside, but it may be barely breathing. While microeconomics is good at describing market structures, it is not suitable for interfering in markets. For example, a couple of years ago, the SA Competition Commission fined Sasol for its involvement in a fertilizer cartel. The Commission required Sasol to divest all but one of its blending facilities and to sell at a price determined by the Commission. The Commission also encouraged the entry of SMEs. A number of years later, an impact study revealed that most of the SMEs had exited the market and that Sasol had closed down its remaining plant. All of these jobs were lost. Competition economics theory is not appropriate for intervention. Having been a competition professional all my life, I've come to realize over the past 5 years as a business owner that there's actually very little resemblance between competition as described in economics handbooks and competition in the real life. For one, a competition authority that is unable to celebrate monopolies cannot celebrate SME development. Each new entrant must bring something unique and differentiated to survive. It must constitute, in theoretical terms, a differentiated monopoly. Where there's no differentiated monopolies, there cannot be SME development. How many African competition authorities celebrate monopolies? As in the health services, regulators' first obligation must be to first do no harm. Healthy supply chains are the only hopes for entrepreneurs, SMEs, HDPs, and consumers. This conference will draw on the insights of 54 brilliant minds to help us refining our approach to African prosperity. The spirit of this conference is open dialogue and constructive conversation, and we invite you to contribute with your comments and your questions. Right, thank you very much for listening to the intro. We are going to start with the first session on settlements. Welcome to our first panel dealing with the question, who has the power in settlement negotiations? Are there limits to authorities bending backwards? And we have an extraordinary set of panel members with us. We are very thankful to Grace Mohamed. She's the Executive Director at Hollard in Namibia, and she's the former Commissioner of the Namibian Competition Commission. We have Advocate Nelly Sakata, an advocate of the High Court, and she's a former Principal Legal Counsel at the SA Competition Commission. We have Dr. Nicolas Bremer, a partner in the competition practice at Bremer LF, Egypt, Morocco, and Saudi Arabia. And we have Sandya Booluck, executive at ENSAfrica in Mauritius, and she's a former Principal Analyst at the COMESA Competition Commission. And their short bios are available at the link in the chat. Before we start with the discussion, it's important just to provide a little bit of background. Since about 2022, we have identified certain power dynamics when it comes to the negotiation of settlement agreements in some countries in Africa. And that power dynamics were characterized by a very interesting combination of behavior. First, the conducting of very aggressive investigations by a competition authority. And some of them were preceded by High Court proceedings in order to fight for jurisdiction over those particular matters. But then, when it comes to the settlement negotiations, there's almost a complete disintegration of regulatory power or authority at that stage. Some of those settlement agreements end up to be quite one-sided and, in fact, highly beneficial to some of the perpetrators, violators of the competition or the consumer law. And in many instances, these settlement agreements caused public outcry, which in turn was ignored by the particular competition authorities. Today, we will consider a couple of cases. We will consider the Morocco fuel case, which had an extraordinary history, pursuant to which the Competition Council entered into a settlement agreement with the fuel cartel members, and they agreed, among others, for the council not to publish the names of the cartel members. Then there was the Nigeria British-American tobacco case, in which the FCCPC agreed, as part of the commercial civil investment with BAT, not to share with the public all of the unlawful conduct that was committed by BAT, but also to withdraw the criminal charges against BAT and also some of the officials, one of the officials. Then, in Namibia, we had the Momentum case, in which the NACCC first gazetted a consent order against Momentum in relation to its involvement in cartel conduct in October last year. But then, in December, it regazetted that consent order. And that second consent order made no reference of Momentum's conduct, even though the first consent agreement was clear that Momentum did engage in the conduct because it stated that Momentum had ceased the conduct. Then we are lastly going to have a look at the Nigeria Coca-Cola case, and this is very recent, in which the FCCPC did a couple of things. After they argued the case before the tribunal, the FCCPC brought a settlement agreement back to the tribunal, and that was one day before the final tribunal judgment was due. And there were vast disparities between the initial order at the beginning of the proceedings and this settlement agreement. For example, the first order included extensive, specific and measurable corrective orders based on evidence and admissions of misconduct, while the consent order was silent on most of these measures, and it also ended a criminal case. The first order imposed a penalty for wrongdoing with clear findings of fault, but the consent order reflected a no-fault settlement despite the FCCPC's prior findings. And then the order's penalty, in terms of the first order, a penalty of 186 million naira was stipulated. And in the second settlement agreement, that penalty was replaced with a amount of the same extent, but it was labeled not as a penalty, but as a reimbursement by Coca-Cola to the FCCPC for services rendered for the FCCPC's investigation costs. Now, about a month ago, while we put this panel together, 2 decisions were delivered by Judge Thomas Okusin of the Nigerian Competition Tribunal in the Coca-Cola matter. And we read those decisions and we thought, don't they to some extent confirm our unease with what we have been seeing? And yes, Judge Thomas will join us tomorrow as part of the South African case on oversight, because we will deal with some similar conduct in that session as well, only in relation to the South African perspective. And just last, and this is really the last that you will hear from me, this has been a very long speech monologue, but just to give you a couple of quotes from the tribunal case of the Nigerian Coca-Cola case. It said, the FCCPC's public role demands that any agreement not only resolves the dispute, but also advances the broader interests of Nigerian consumers. Deviations risk judicial rejection and undermine the FCCPC's credibility as a regulator. In enforcement actions, including litigation before this tribunal, parties act not merely in their private capacities, but within a framework designed to uphold broader public interest objectives. Then, the parties, together with their legal representatives, have a duty to ensure that their actions within regulatory proceedings do not undermine the statutory purpose for which such proceedings exist. It also said that in circumstances where there are established findings or persuasive indications of conduct detrimental to consumers, such findings are not to be treated as extinguishable by mere agreement. It said that an agreement that obliterates the basis of inquiry is void and against public policy. It said it is against public policy for a negotiated commercial civil settlement to end a criminal case, especially when parties jointly agree to compromise factual basis, investigative findings, and conclusions. It said, as a court of record, the tribunal must uphold its integrity and public duty, not act as a conduit for private agreements, where private agreements refer to agreements between the regulator and the commercial entity. The settlement's attempt to bypass public interest, consumer welfare and market fairness is deemed void and contrary to public policy. It said any reading of the tribunal's rules or policy to encourage amicable resolution of regulatory disputes as empowering the FCCPC to enter into contracts with those it regulates, including negotiated agreements that tie the hands of the Commission not to discharge a statutory mandate, is mischievous. The rules and policies of the tribunal can never encourage something that is against public interest and public policy. And then just the last quote, a consent order means that an undertaking investigated has saved the FCCPC the need to either complete an investigation, which may include lengthy reports and procedures, and the need for the additional apparatus to enforce and compel obedience, and the assurance that it will not be appealed, bringing closure. This is different from a contractual settlement, which indicates discretion. Right, that was a very long introduction, and I'm sorry for that, but it was very necessary to properly explain and contextualize what we are talking about here today, because this is something that we picked up, and it is quite important for us to make sure that the attendees also understand the context. So today we will consider, are there limits to authorities bending backwards in settlement agreements? So Advocate Nelly, let's start with you. If you can switch if you can unmute yourself. According to the Nigerian tribunal, while regulators are encouraged to settle cases, such settlements must serve the public interest, it must be supported by law, it must not limit regulatory responsibilities, and also not constitutional responsibilities. And what does it mean for a settlement agreement to comply with those four guidelines?
Yes, thank you so much, Odie. So first, settlement agreement play a crucial role when it comes to competition enforcement. In the Competition Appeal Court decision, Netcare versus the Netcare and versus the Commission.
Yeah.
In fact, it's an old case. It's 2008, but the decision, in fact, set very good principles when it comes to settlement agreement. And it says, and I'm just paraphrasing, that settlement process is intended to bring about expeditious conclusion of cases, avoid protracted hearings, and conserve resources. But it also insisted that it must achieve the objectives of the act as well as public interest. So when it comes to what it means by serving the public interest, we see that it has to serve the objectives of the act. There are different acts. Each country in Africa have different acts, but just to zoom into the Competition Act in South Africa, are specific. If we look at the purpose of the act in Section 2, it set out basically some purposes include also the public interest. So as part of the ensuring that it serves the public interest, Netcare also mentioned that a consent agreement, which will not be regarded, if I can just paraphrase, as achieving the public interest or public policy, if it imposes an inordinately a very low penalty, for example, or if it does not address the harm that was caused by the conduct. For a settlement agreement to serve the public interest, it generally means that the terms of settlement effectively address the harm caused by the contravention, promote the competition that has been affected by the conduct, and deter also future anti-competitive conduct. So those are mainly the three. So if I can quickly jump to what it means by a consent agreement to be supported by law. Again, in the Netcare decision by the Competition Appeal Court, there is a test that the Competition Appeal Court provided, and I think it's a test that talks about also a compliance with the law. Being supported by the law means not only that the consent agreement must have been concluded in terms of the provision that allows consent agreement. So, for example, in South Africa, it's Section 49D, and I do recall from the decision also of the Nigerian, the Coca-Cola one, they do specify it. So that's when it talks about complying with, it must be supported with by the law. But again, going back to the rationality, that it does not offend the objective of the act, and that it has to be rational. And the question has always been, what does it mean by having a rational consent agreement? And the courts have actually pronounced that there has to be a link between the remedy that is proposed by the consent agreement and the harm. So the support of the being supported by the law is that it has to be within the regulatory statutory power of the commission or of the institution to conclude the agreement. It must not go against the purpose of the law, the purpose of competition law, which is to maintain competition and also looking at the consumer welfare, and it must be legally enforceable and procedurally sound. And quickly to jump into the third element as to what does it mean by a consent agreement to be in line with authorities' regulatory responsibilities. We just to give still the example of the Netcare decision, and there's been many cases, but this is one of the precedent, is that what happened in that specific case, the tribunal had first refused to confirm the consent agreement. And it refused by explaining that it was because the agreement did not give a satisfactory explanation as to what in that case it was a failure to notify the merger. So there was not a specific satisfactory explanation of the conduct. And it brings me to the answer to what does it mean by being in line with the authority regulatory responsibilities, because it has to, at the end of the day, a consent agreement will have to take into account what is the harm or what is the fault that is being addressed. And going outside of that, not addressing what harm has been caused, it can be criticized of not being in line with the authority regulatory responsibilities. And it takes us back to the objective of the Act and also promoting the public interest. And the final one, it's to be in line with the constitutional responsibilities. And I think on that one, the Nigerian decision, the tribunal decision that you've just mentioned on the Coca-Cola one, is really on point. Because in that specific decision, the tribunal, the court insisted again that in concluding a consent agreement, the parties, including the commission, must not forget about, and it's just a lay term the way I'm putting it, but must not forget about the constitutional responsibilities. And it takes back into ensuring effective enforcement of the Act, protecting the fundamental right, serving the public good, because, and I think that's what you've mentioned in your introduction, that competition law cannot be seen in a vacuum. At the end of the day, the promotion of competition it's actually about promoting, ensuring that consumer welfare, ensuring that consumers or the public have access to product choice and in competitive prices. And it links to the constitutional responsibilities of the institution, particularly the competition authority, the commission, to ensure that fundamental rights are protected, serving the public good. And yeah, I will stop there.
Right. If there is public outcry pursuant to a decision by the competition authorities in relation to a settlement agreement, would that be an indication that the settlement agreement is against the public interest or not necessarily?
Well, it depends. And it takes into consideration what you have said earlier. You've mentioned the number of cases nowadays where there is no disclosure of the perpetrator, of even not disclosure of the conduct. And that's where there may be public outcry about this kind of settlement. And that's where public interest may be affected, because at the end of the day, the public has the right to know. And I think it goes into the constitutional responsibilities of the institution.
Yes.
And it can only be, one will only be able to determine that it goes against the public interest, if the public is aware about what the conduct is all about. We have also examples of consent agreements where the conduct that was alleged to be a contravention of the Competition Act was actually not even a contravention of the Competition Act. So
that's correct. Yes. For some reason, Mr. Babatunde is not with us today. I'm not sure what has happened. I'm sure there's a great reason for that. But Mr. Babatunde was the CEO at the time of the BAT investigation at the Nigeria FCCPC. And a very interesting thing happened there, as I indicated, that they agreed with BAT not to disclose certain particular conduct. And I'd just like to hear from you, Grace, if we take that argument to the extreme, if we say that that could be allowed in each and every settlement agreement not to disclose the conduct of a company that violated the law, what would be the end result? In which way would a competition system be weakened or strengthened?
So firstly, Odie, thank you so much. It's certainly a privilege to be party to a very topical conversation. And I think the issues that you want us to chat is very apparent in my market. And similar to you, having now worn the authority and investigator, first an investigator and then a commissioner head, and now being in private sector, competition certainly is not as apparent as we think when we're at the authority side. So there could be legitimate reasons, right, for not disclosing some information to the public. But I think, like Nelly rightfully says, these should be informed by law, right? There could be issues around commercial sensitive information, protecting a whistleblower, protecting parallel investigations.
Exactly.
There could be a errand of reasons why you're not disclosing, but even that non-disclosure should be explained to the public, right? Because for administrative bodies like competition authority, there is the advocacy aspect, right? And in establishing jurisprudence.
Yes.
So it becomes very important to explain in instances when authorities do not disclose information, why it is not being disclosed, because in not doing so, there's the great potential of having harm the reputation of the authority itself, right?
Yes.
It's a slippery slope to becoming captured.
Exactly.
It's a very slippery slope. So without explaining, it also creates an illusion in the market that offenders can get away with certain things without being quote unquote shamed for their conduct, right? And it also harms the reputation. So citizens, because markets operate because there must be some transparency and degree of knowing what would happen, right?
Yes.
If I contravene, right? So the yardstick of the penalty must be known. What I can do to navigate if I find myself in contravention must be known. So there's an obligation to be transparent in the interest of public policy, establishment of jurisprudence, because settlements, more than anything, are tools of enforcement, right?
Exactly.
They must not be used to hide and cover and almost enforce the abuse in asymmetry in information that exists.
Yes.
So to your question, if there's a public outcry, for me, it could be two things, right? If the public was party to the process, right, the investigative process, and they've made submissions in the ordinary course of these investigations, and then the authority shows up one day and does not disclose the reason for its actions, you can imagine why there would be a public outcry, because they are not appeasing the public for why they've come to a particular decision and why they're acting in a particular decision. So I don't think it's as straightforward that if there's a public outcry, therefore,
Exactly.
there's cause for concern, but there's cause for concern if public outcry is because we've not listened to the public, we're unable to explain to the public. There's an element of education and literacy, as we know. This is an extremely technical field, and what the public often hears is often not what is the case. I think I would rest it there for now.
Right. Thanks so much. That's been very helpful, Grace. We are very glad to see Mr. Babatunde Irukera. Thank you so much for joining us. Mr.
Sorry, I'm late. I thought I was on time.
No problem at all. I think it's the time difference. Mr. Babatunde, if we can have a look at the BAT case. You had the privileged position to be at the FCCPC at the time when the negotiations were done with BAT. And we understand that certain of their conduct could not be disclosed to the public. Can you explain to us some of the complexities that you had to deal with as part of that whole negotiation process?
The reality is the nature of the discoveries were quite conflated. The Nigerian authority is both a consumer protection and a competition authority. And not just that, it's also a designated agency for the enforcement of the NTCA, which is the National Tobacco Control Act.
Yes, that's right, yes.
Nigeria's commitment and compliance with the Framework Convention of the WHO.
Yes.
And so the FCCPC was wearing multiple hats in that investigation and discovered things that even some of the discoveries and some of the violations were even more so of the tobacco control laws sometimes than the competition aspect of the work.
Yes.
And so managing disclosures from a competition standpoint was tricky. And then some of the issues that arose were things like export control laws, foreign exchange violations, which are treated quite differently. And some of them, even though they were not direct competition violations, they had indirect competition effect in the market, in the sense of providing an advantage to a business over others that were not willing to do the same thing. And so we had to scrub for what the type of competition disclosures that needed to be made, one, two, and then coordinate with other agencies with how they manage the stuff like customs and all of that. That is their own core, where their discretion in how they proceed was fundamental. Yes. And then the part of that that was actually, I would say, perhaps in consideration of the company, was that they had similar or other situations that were pending in other jurisdictions where they thought some of the disclosures that we could make could be preemptive or prejudicial in those investigations. A lot of considerations that guided how we concluded what to say and when we said it.
That's fascinating. It definitely provides some of a better indication of the complexities that you had to face in that regard. Thank you, Mr. Irukera. If I can ask Sandya to quickly give us your view on the issue. The Coca-Cola case, in that case, the tribunal said that parties, together with their legal representatives, have a duty to ensure that their actions within regulatory proceedings do not undermine the statutory purpose of the proceedings. And what do you make of that, especially now that you are on the other side? And what would you say, what does they say in terms of the parameters within which legal representatives and their clients must come to the authority in the context of a settlement agreement?
Thank you, Odie. And indeed, this is my new venture on the dark side of competition law. as I've been saying. So respectfully, I have to say that I do not fully agree with that view. I think I certainly understand the emotion behind it in the context of a Nigerian tribunal decision, but I think as a general view, it imposes a higher burden than is necessary on parties. So certainly it is desirable to have settlements that reflect the statutory purpose of these proceedings, that advance public interest. But I think we also have to be realistic about the incentives and the roles which are at play. You have economic actors and their legal representatives who, by design, are incentivized to secure the most favorable commercial outcome for them. So I think it is quite normal that they will try to exploit any permissible procedural and substantive avenue in any adversarial process, as long as it's within the bounds of the law. So I think to expect parties to self-censor or to limit their negotiation strategy out of deference to the regulators' need to satisfy any statutory objectives or purpose, it's a conflation of roles, because you have a regulator, you have a regulated entity, you have the legal representatives, and each one fulfills a distinctive role within the adversarial process. And I think it's that clash of competing interests that actually is meant to bring about a more effective enforcement outcome. So it's certainly not, it won't be achieved by having a voluntary restraint by one side out of service for the other side's objectives. And I think in that sense, the legal framework is there to provide the necessary checks and balances. That this has, and I think that's what the tribunal decision also reflects. It comes in as that oversight. So I do think it is for the regulator to safeguard the interest, and for the courts to ensure that any settlement or consent order is lawful. And I think, as Nelly and Grace already mentioned, it has to adequately address all the competition concerns or public interest concerns that have been identified, and it's not generally contrary to the public interest. And I can make a quick reference to what happened in COMESA recently. And just a very quick background for any attendees who might not be familiar with the case. So the Commission in 2017 started investigations into exclusive agreements between CAF, the Confederation of African Football, and various pay TV broadcasters. Now, the last one was decided upon, I think, in March of this year. So that's like 7 to 8 years in the making. So what happened, the Commission issued a decision finding the agreement to be in breach of the regulations, and the parties were fined. So the parties naturally appealed the decision. The hearing for the appeal proceeded. The parties each defended their position. So the parties and the Commission defended their position. And just before the appeals board was going to rule or was going to adjourn the meeting in order to make its judgment, the parties sought the leave of the appeals board in order to enter into negotiation discussions. And what the reasons that were put forward was, again, it marries with what Nelly said at the beginning. It's for judicial economy, for efficient resolution of the case. Like I mentioned, this is a case which is 7 to 8 years in the running. You are depleting the resources of the Commission just on one particular case. And I think what the difference that shows is that in that particular case, the parties respected the process. And I think that is the duty of parties, and that is the duties of their legal representatives. You have to safeguard the procedural integrity of the system. I think that the other difference is also that they were quite transparent in terms of the reasons for wanting to enter into this commitment negotiation. I think there was fatigue on everybody's side, not just the Commission, but even I think for the parties. And in those instances, it makes sense.
Yeah,
I think to enter into such type of conversation. So I think that the difference there was really that the manner in which the process was respected, which perhaps was not entirely the case in the Nigerian case.
Yes.
I think there you need to allow the tribunal and the courts to be able to play their role as the independent decision maker. So to summarize, I would say I agree that settlements should not be contrary to the public interest in principle, but it is not the duty of parties and legal representatives to be the custodian of the regulator's statutory body. You can have robust negotiations, you can have regulatory oversight. The two are not mutually exclusive.
That's a good point. That's a great point. Moving to Dr. Nicolas, in your view, should there be a minimum standard of disclosure from a normative perspective, in your view, by a competition authority when they settle with a party pursuant to some sort of violation? What do you think? How should it be?
I mean, minimum standards or procedures or requirements are in some sense actually contrary to the concept of settlement, because I mean the settlement is intended as a more flexible procedure. That is not to say that there cannot be abuse of this authority or of this principle, where the intention of sort of a settlement is in many jurisdictions at least that certain minor violations might not warrant a more aggressive approach towards the parties that would be involved in sort of a naming and shaming penalty. But of course, I mean, the fuel cartel case in Morocco was mentioned a couple of times. There's also the consideration what really does constitute a minor violation, and where is that line crossed, and where we then are getting into conflict with public interest aspects, and even the basic sort of intention of a competition law regime, because not disclose or not making use of disclosure authorities or powers then hinders or possibly hinders effective enforcement of a competition regime, because obviously the monetary penalties or settlement payments that will be involved in certain settlements are one aspect of ensuring future compliance, but obviously the disclosure of party names, the naming and shaming aspect of this is a much stronger incentive in a lot of cases. These public relation risks are being taken very serious by parties, and we get that in our practice quite a lot. The question of whether confidential settlements can be reached in certain cases, and that seeps into the risk evaluation of parties. So I would not say that there necessarily has to be a minimum standard for what has to be disclosed, because that would impair the flexibility that a settlement is supposed to provide. But there has to be a good understanding, or there has to be a measured approach as to where the line is crossed and where more serious measures have to be taken, which don't necessarily have to be violations enforcement that go beyond a settlement, but for example could include disclosure of certain elements. I mean, similarly, we had that discussion in relation, for example, with leniency regimes, where regulators realized that there was a or we could observe a decrease in leniency applications where third-party damages were becoming more severe than the fines actually imposed, and parties were reluctant to sort of go that way. And then there were discussions about whether you could sort of support a leniency regime by offering to not disclose those parties that made use of the leniency regimes, which then puts you in the position again that you have a potential conflict with public interest because maybe affected parties could not effectively reclaim their damages. And so we're sort of in a conflict of where do we balance this? But that again brings me to that point where it becomes imperative to define where is that line, where do we think effective competition can be promoted in the case of the leniency applications by allowing confidentiality, and where does it become where would such a benefit or be out of proportion to the violation and the interest of the public.
Right. Thank you, Nicolas. It's also very interesting that you say that whether there will be naming and shaming forms part of the risk assessment as to whether certain conduct should be tried at least. That is actually quite significant. Mr. Irukera, is it always good to settle? And I'm thinking of the outcry that there was, I think it was in Morocco, it was in the terms of the fuel price investigation case, well, the fuel cartel case. Now, what happened there is, I think that investigation started in 2016 and it concluded in 2020, but then there was a big issue regarding the irregularity of that investigation. And the head of the council was asked to resign, and 3 sets of legislative documents had to be amended. The one was the Competition Act, the one was the Council Act, and the other one was the Council Procedure Rules. And that took 3 years, and that was in the period of COVID and the Ukraine-Russia war and droughts and coups in that area of Africa. And in the meantime, the cartel had a field day. And by the time that the new board was constituted and the investigation, well, the second investigation was concluded and they decided, let's bring everything to a finality, there's been so much harm done. So could there be instances where a competition authority that have a lot of hard evidence against a cartel should proceed with a prosecution? In other words, would a settlement in certain instances be against the public interest because it's not a prosecution, or are there always places for settlement agreements?
Oh, the right response to this is actually all in the shades of gray, neither black or white, in my personal opinion. I think that there is merit to accountability, which usually comes from prosecuting cases and finding people guilty. But you must also remember that for the most part, what competition authorities are doing is regulating commerce. And regulating commerce is different from somebody's going to steal or violent crimes. And so when the regulators are sufficiently trained, they know exactly how to proceed. And so I would say that from a general broad stroke standpoint, it is always good to settle. It saves regulatory time and effort, allowing the regulators to go focus on other things that are going on in the market on a daily basis. It also can mitigate harm in the sense that you can address the harm that's going on in the market very quickly with finality and mutuality, as a matter of fact. It also promotes, what is the broader objectives of regulation anyway: stability, predictability, and less interference with business. Now, are there circumstances when a settlement is not necessarily inappropriate, but a settlement procured is not the best outcome? Oh, absolutely. So it will come down to what is settled, how it is settled. I mean, there are settlements that are no-fault settlements. There are settlements that are admissions of liability on some grounds. And it's almost like saying that it's a plea bargain a good thing when a prosecutor is allowed to hold somebody accountable for different offenses while they cut them loose on other offenses. Overall, broadly speaking, those are very positive things. And I might add that it's becoming better on a daily basis with the body of jurisprudence that's developing around it. And using the example of the Coca-Cola case, I think listening to you and reading the material and listening to Sandya, I think what is most important, the biggest lesson in that really is how to proceed, not necessarily what the content was. I think when you seek to settle a case at a point where it's been so adversarial and the case is so completely, fully briefed before a tribunal or a judicial authority, and to some extent, they've already made an opinion about what they think of the case and what the previous order, what the orders were that is about to be negotiated. You're riding against the storm when you come in and say, well, by the way, we want to settle this and say that nobody did anything wrong. Both parties have surrendered a significant portion of the trust and discretion that is statutorily imposed in the regulator to negotiate and compromise cases based on its own wisdom and discretion. By the time you fought this hard and briefed the case and argued before a court, and the court already has a sense of its view about the case, it's difficult to come and settle that case in a manner that disregards everything. So I would say that the biggest lesson from that is learning when. And also the fact that a tribunal has done that also sends a clear message to everybody, both the regulators and the parties also, that in this settlement, we must keep our eye on the things that are most important. Anyway, businesses know what to expect in a potential settlement. Regulators know what to run away from so that they don't get scalded when it goes further up. So I'd say that this adds to the body of jurisprudence that promotes the positivity of settlement instead of driving us away from it. It just means that our settlement should be far more robust and better.
Thank you very much, Mr. Irukera. I'm mindful of the time, and I know everybody basically had only one chance to say something. It was quite intensive cases that we dealt with. Is there a final word from everyone? Maybe just taking in a concise way, just give your thoughts in relation to the question of, are there limits to authorities bending backwards? And if so, what are the main things to consider, or even just something that stood out for you as something that you will take from this discussion? Nelly, shall we start with you?
Yes, thank you. And I hope I will be quick. I have a tendency of just going. But I liked what Mr. Irukera said. It's about having settlement that should be far more robust. And I appreciate also what the tribunal or the court did in Nigeria, in the sense that, in fact, it did not just rubber stamp the decision of between the two parties. It was very robust about questioning. And we see that also with a lot of consent agreement in South Africa, where the tribunal does not just accept. In fact, there is a lot of inquiries. But I think it's really linked to the act. What does the legislation says about the settling, entering into a consent agreement? But I think for me, it's very important that the authorities, especially the court, do not just simply rubber stamp, but to really question in order to achieve what the competition legislation has said. And just one last thing, and I keep on going back to the Netcare case, it's because there is a test that the Competition Appeal Court have actually developed into assessing whether a settlement agreement is can be robust, as Mr. Irukera said. And it says that it must be rational. It must meet the objective of the act. And if the objective of the act include a public interest, it must meet those objectives. And finally, it must not be so shockingly inappropriate that it will also affect competition. So those are my few words. Thank you.
Thank you very much, Nelly. Nicolas, from your side, just a final thought.
Yeah, but I mean, I think in summary, settlement agreements or settlements with the authority for violations are an important tool, especially to address lesser offenses. And then if we pull in something like leniency applications that are intended to increase or to support investigative powers of the authorities, and specifically in developing jurisdictions where the authorities might not have sophisticated investigative tools or capacity to do so. But the one thing that I would think is important to keep in mind is the proportionality. Meaning that where in some cases of minor infractions you might consider sort of a softer settlement to be relevant because of the circumstances of the case. If we have harsh violations, a settlement has to reflect that, and maybe a settlement would even ultimately not be the right tool to address that, and you might have to progressive to prosecution and more severe fines or penalties. But the core element to that evaluation is proportionality in my mind. And I do realize that with a lot of African authorities, we're talking about authorities that are young comparatively, if we look globally, and the evaluation and the proportionality argument is a difficult one to assess, and it takes experience, which we see in certain African jurisdictions, but for example in Morocco, where we have a rather young authority, that might still be somewhat difficult for the authority to address due to the lack of sort of institutional experience.
Yes, thank you very much, Nicolas. Grace, your final thoughts.
I think Nicolas makes very important observations. I think his observation is true, especially in countries like Namibia, where settlements more than anything appears to be used as a trump card for authorities as they grow, right? And often places parties in very uncomfortable positions to settle. The Momentum one is case in point, when African authorities are still learning the ropes and are faced with experienced counsel, the likes of Sandya and Nelly, to try and intervene in such discussions can be very tenuous. But it's with that the growth comes. So I don't think authorities bend backwards, especially in their formative years. In their formative years, they are very difficult. They are almost hard-headed, and almost trying to apply the law in its crudest manner.
That's interesting.
They are the most difficult authorities to negotiate with because the flexibility and consideration of proportionality is not embedded.
That's interesting.
I don't think they because the power dynamics, right? And they almost want to settle for the sake of settling, whether there's merit in the case. And so often they're not. I think almost the Momentum case is one, because I had both jobs in the Momentum. I interviewed or presided over the Momentum case.
Yeah.
Momentum was 6 months old. It was very evident to me, but the team was adamant. It was very clear to me that Momentum potentially should not be party to this case, but the team was adamant. And so when you read the judgment, I think these things must be considered on a case-by-case basis. There are nuances.
Yes.
But young authorities in African, they don't bend backwards. I just want to say they definitely, it takes a miracle for you to get through to them.
Thank you so much, Grace. That's a fascinating observation. Sands, over to you for the last words.
Thank you. I do agree with what my fellow panelists have said, and I think it's very interesting because COMESA is going through the process of amending its regulations. And the draft that was published early last year actually introduces a leniency policy. And what was interesting about that is that it makes no mention about needing an admission of guilt. And I think this conversation and this case law is coming at a very interesting time for them as well, because I'm sure there'll be further refinements to the proposed amendment. So it will be interesting to see what finally comes out once they do amend the law. But yes, to agree, I don't think bending backwards is inherently problematic. I think it is necessary sometimes in order to achieve an effective enforcement. I think the enforcers on the panel will agree penalties and confessions alone don't fix markets, right? At the end of the day, you're trying to promote and maintain competitive markets that work for everyone, and you need those compromises. But it's just a matter of making sure you have pragmatism meeting principles. You need deterrence, you need justice, you need to preserve procedural integrity, also while achieving realistic and meaningful outcomes. Very easy to say, but quite difficult to achieve.
Thank you so much for the wonderful contributions today. It's been a learning experience for me. It's been fascinating speaking to all of you and hearing how you complexify an issue that must be complexified, because sometimes one can think overly simplistic about what's right and wrong. And thank you so much for your wonderful, wonderful contributions. It's been fantastic. And for all your hard work in getting us to this point of this discussion.